A very good day to all of you. Today's session will focus on Incoterms. As most of you are aware, we have the 2020 version, which is effective 1st of January 2020. We had the 2010 version, which was valid earlier. Today's session will just focus on Incoterms and also a bit about what are the variations which are coming from the 2010 version, especially with respect to the new term which has been introduced, some of the terms which has been substituted, and also looking at the application, where exactly is this applied, because there is a lot of confusion still with respect to the application of the Incoterms, whether it's in the sales contract for the goods or in the contract of carriage, or is it both, because inadvertently some of these terms are used in different contracts where it may not have the real legal standing with respect to the meaning of that particular term. So we'll analyze some of that, and how would you exactly go about choosing the right term, or with an existing contract to know, is this the right term to be used in this contract, or if you still need to use that particular term, what are the risks or the gaps which are involved in that particular contract, which can be mitigated by other means. Before we jump into the various details of Incoterms, it's essential to understand how does a contract function. What are the various contracts which are in place in a normal business? So we look at those aspects of general contracts, contracting principles, details which comes in a contract, and then look at the details which comes in a sales contract. Let us look at the aspects of trade. There are three things which are important in any trade. We are talking about trading of goods. The first one is the movement of goods. A trade implies that there is movement of goods because there is production of goods in one area of the world, which has to be moved to a consumption area which somebody is buying in another part of the world, and therefore there is physical movement of goods. The second aspect which moves in a trade is information. It's very easy to plan the movement of the goods, but it becomes useless for using at the destination if the right information or the documents which represents that particular goods is not available for the required clearances, after which only the goods can be used. The third thing which moves in a trade is money. There is no business without the involvement of money. Businesses exist for a profit, and therefore as important as planning for the movement of the goods and the related information, it is also important to see how does money flow in the system. International trade is different from domestic trade. Because of this, there are additional challenges which comes into play. Let us look at some of the factors which needs to be considered in international trade. The first one is the time factor. Right from the time of placement of order from the place of consumption to your supplier to the actual delivery, the entire lead time which is there is huge for an international trade, especially if the transit time is more, say it is by sea shipment, the time factor increases considerably. Second is the use of different legal systems. It varies from country to country. Even though you may specify a particular legal entity to be used or a jurisdiction to be used in that contract, the way it is interpreted in different countries can be different. The supplier may insist on their own legal system, whereas the buyer may insist on their own legal system. The documents which are used or the parties who are involved in complete accomplishment of that particular trade or that particular movement, all those things add to the complexity of the legal system. Third one is trading practices. We assume when we do a domestic trade, there are a lot of assumptions which are done in the way a trade is done. You go to a petrol pump to fill petrol or gas, you assume that yes, in a particular country, you assume that you just park your car and everything is taken care of by the attendant. The same is not true in another country where you would have to get down and fill the petrol yourselves. So similarly, in trade as well, in trading of goods also, there are a lot of variations. Even if it's the same kind of commodity or same kind of an industry, trading practices vary a lot from country to country, or even between city to city in a huge country. The next one are various other differences, which can be ethnic, cultural, social factors, which all adds up to the way the trade is done, the way a labeling is done, the way certain things are expressed, or even in a meeting, how people conduct, or how an email is sent. All these kind of differences comes up very evidently in international trade. And last but not the least is with respect to the security for payment. A trade is complete, or a business is complete, or a transaction is complete not when the goods are shipped or not when the goods are received, but it is when the payment for that good, that particular cycle is completed, which is in ERP parlance, it is known as order to cash. So a seller, by virtue of his own risk management, he wants to get paid as soon as the goods are shipped, or better, he wants to get paid in advance. Whereas the buyer is wary, who is sitting on the other part of the world, is concerned whether he will get the goods on time, whether the goods which are coming are properly packed, whether it's the same specification, whether it comes without damage. So he's also concerned about a lot of aspects. And then there are a lot of other concerns which are common to both the parties. So therefore, security for payment is an important part in the whole chain. Let us now look at how these interfaces work. There are many contracts which are there in an international trade. The first one, of course, obviously, is the contract of sale. As I mentioned in the beginning, you've got a seller in one place who is selling the goods to a buyer in another part of the world, and therefore they enter into a contract which is typically known as the contract of sale or contract of purchase. Now, to execute this particular contract, we need a contract of carriage, which means you have to entrust the movement of these goods to somebody else, a carrier who is going to carry the goods physically. So typically we call it as a contract between the merchant and the carrier, because the merchant here can either be the seller or the buyer, or it can be both. Moving from point A to B can involve multiple stages where it is moved from point A to C by the seller and from C to B by the buyer. So therefore, you could have multiple contracts of carriage in a single transaction or in a single trade. The third one is with respect to the contract of insurance. Though we don't obviously or always call it as a contract, it is a contract which is existing between the person who's insuring the cargo on behalf of the party who wants the risk to be mitigated and the assured. Again here, it can be the seller or the buyer depending upon the terms of the contract of sale. Again, it can be agreed that the risk from point A to B is with the seller and from B to C is with the buyer. So again, just like contract of carriage, you could have multiple contracts of insurance which exist within a single transaction in a single business. And then the fourth one comes, though it is not again explicitly known as a contract, the aspects which are related to export from one country and import into the other country is governed by the local regulations. So customs clearance becomes an important part. Who has to do the clearance? What are the documents which are required? What are the financial implications with respect to duties? What are the other clearances which are required in advance, whether it's an export permit, import permit? All these aspects comes under the realm of customs clearance. Let us look broadly at the consideration which comes in contracts. So the first one is the physical nature of goods. So you could have bulk goods which are known as unascertained. So you want to buy 100 kgs of rice. You can specify as to what should be the quality of that rice, but you don't exactly know how or from which lot it is going to be given. Same case say with bulk liquid products. But when it comes to say machineries or a specific item which you are buying, it can be a real specific goods which can be mentioned in the contract. Second is how are the goods moved? What are the different modes of transport which are used? Is it going to be in a single mode of transport? Is it going to be multiple modes of transport? The division of costs between the parties involved. So here, if you're taking the sales contract as an example, you've got two parties there. What are the costs which the seller is going to bear and what are the costs which the buyer is going to bear? This is something which has to be explicitly mentioned in the contract. Responsibility for the task can be different from the division of cost. Even though party A is bearing the cost, it can be that the responsibility for completing that task could be with the other party. So this needs to be mentioned specifically. And then the most important thing with respect to risk on the potential loss or damage to the goods. Again, this can be different from responsibility and it can be different from division of cost. It can be different from the actual movement of the goods. So this is another aspect which needs to be mentioned in the contract. What are the elements in a basic contract? So the first one to understand is there a difference between agreement and contract? An agreement is a particular aspect which can be between two parties where they agree to do certain things. But when does it become a contract? The first one is that for anything to be binding, there should be an offer with a validity, and then there has to be a complete acceptance from the other party. Not having acceptance or a silent acceptance is not considered as a legal position for the parties involved to enforce that particular contract. There has to be a consideration, which means when you're giving something, you have to get something in return, which is in line with the value of that particular goods or value of that particular service. So that's known as a consideration. So a contract to be valid, there had to be a consideration. Consideration has to be mutual and it should be of potential equal value. Consideration can be in kind. It need not always have money which is involved. Somebody who's agreeing to mow your lawn and you're just giving chocolates as return is a consideration. But does that become a contract? Not really, because another important element of a contract is the intent to create legal relation, which means that a contract would be binding on both parties only if there is a recourse to non-performance, which can come with respect to giving a jurisdiction or arbitration or both. Who are the various parties involved in a trade? Broadly, we will see many of these terms which are used in contracts. To start with, you have the seller, the buyer. Sometimes you would find different terms like the consignee and the consignor as to who actually is handling the goods. It could be that the seller and the consignor is the same, or the buyer and consignee are the same parties, but need not be the same. Then when it comes to payments, especially involving letters of credit, which we'll discuss in a separate session, is where you will find terms like beneficiaries, applicants, and issuing bank, advising bank, etc. Exporter and importer. Again, exporter could be the same as seller, but need not be the same. It could be somebody who is just having the export permit and managing the whole goods on behalf of somebody. On the other hand, then you have third parties, this is where additional contracts come into play. It could be the main carrier, the forwarder who is just acting as an agent of that carrier, other agents who are involved in that particular chain, packaging, warehousing, inspection of the cargo or inspection of the equipments, insurance, which could be for the goods or related equipments. Then you've got port and terminal who act as interfaces for the goods, and then ultimately customs authorities who regulate. What are some of the main the parameters? So we discussed about goods, which is specific goods or uncertain, primarily in bulk. Then you need to define something known as property, right? It's property or otherwise known as title of the goods, which means that who owns the goods at what stage? When does the actual ownership of the goods pass from the seller to the buyer? Because this is extremely important, because especially in matters of insurance, you have to prove that you have an interest in that particular goods at that particular point. Then only you would be deemed to have an insurable interest and you can insure the goods. Sometimes the aspect of title is linked to payment. The contract may say that only upon a receipt of payment of the goods for the goods, as per the invoice, as per the value agreed, the title would pass, which means that only after that time the buyer would have the authority to say that they are the owner of the goods, or it is guided by the intent of the contract. So many times if these things are not explicitly mentioned, in case of a dispute, it goes as per what was intended in the contract or what are the norms in place or practices in that particular place. Third thing is about risk. There is always a danger of damage to the goods or potential loss which can happen in transit, and therefore it is important to know who has got the risk in which stage of that particular moment. Another thing is that title and risk can be passing at different stages. Many times it is assumed that title and risk pass at the same time. It need not be, because where in jurisdictions where there are tax implications, your risk may transfer to the buyer earlier than the point where the title is transferred. So this is where, especially with respect to risk, is where the relevance to Incoterms comes in. And to mitigate that, you have to have an insurance. So risk is mitigated having an insurance on the cargo. Some of the other aspects or parameters which comes with respect to goods or which needs to be in the contract: who are the parties involved, what is the quantity and the different ways in which quantity is expressed, the unit, the range, the tolerance, delivery, what is the time, is there an agreed time of delivery, is there an agreed place of delivery, what is the mode of transport to be used, what is the type of packaging to be used, the pricing of that particular transaction, what currency is used, is there it's a fixed price or linked to a market index, or there are any variable pricing mechanisms, and what are some of the non-product services. Freight and insurance are not directly linked to the product price, but if a seller is selling it including freight and insurance, is it something which is included as a lump sum in the whole price, or is it something which is mentioned separately? And ultimately, what is the currency which is used and what are the payment terms? Other aspects, you got inspection of equipment. So if a container is used, the container has to be good. So you could be having parties to inspect and provide a certificate. Then of course the cargo inspection, which can be testing, specifications, or even just tallying. What is applicable law? Again, it can be explicitly agreed in the contract as to what is the jurisdiction, but it can also be guided with respect to the domicile of the parties involved or where the documents are issued. And if at all a dispute comes, how is it going to be resolved? Is there a provision for mediation, arbitration, and if everything else fails, into taking it to a court of law? And sometimes you will find that standard terms and conditions apply. So it's always good to know what those standard terms and conditions are. In today's world in electronic media, Many times you just find that please refer our website for standard terms and conditions. So those are implied conditions which has to be verified, so to ensure that there is no conflict between the main contract which is agreed and the standard terms and conditions. One of the easiest way to understand trade or even the related logistics is to look at examples from our daily life. So here let me depict some of the normal transactions which we do and then relate them to the specific Incoterms. Shopping from a supermarket. I'm sure that all of us do this or have done this, right? So let us ask. So there's somebody who's selling these items and I am there going in as a buyer buying these items from the supermarket. So is there a contract of sale here? Though we may not be negotiating item by item or for a complete purchase which is being done on a day, there are contracts of sale which are explicit. The invoice which is being given which says standard or general terms and conditions apply is in fact a contract of sale. It constitutes an explicit contract of sale. What about Incoterms? So if there is a contract of sale, there has to be Incoterms, but we never go to a supermarket and say that I want to buy milk on Ex Works basis or on FOB basis, or please deliver to my doorstep on DDP basis, right? So it implies that yes, though we have a contract of sale, we are buying and selling, the transaction is similar to what happens in an international trade, but the extent of risk which is there or the number of parties involved or the complexities are much lesser as compared to an international trade in normal business, and therefore we don't see an Incoterm which is being used in these kind of transaction. What about contract of carriage? Well, these are also something which are inbuilt, where I'm driving my car, going to the supermarket, picking up the items and bringing it to my home. There is no implicit contract of carriage there because I'm doing it myself. What about point of transfer of risk? When do we actually pay for these items? We generally pay for these items only at the check-in counter, but the items are already in my physical possession when I pick it up from the shelf. What happens if I drop a couple of these items, a bottle of milk or a bottle of jam, and the goods are damaged or lost? I have not yet paid for it. The title is not yet transferred to me, but the risk of damage or loss to those goods was already with me when I picked it up from the shelf of the supermarket. In a normal case, the supermarket owner may say that it can be covered under their operational loss, but imagine that it is something which is much more valuable. He would say that the moment I pick up the item, the risk is transferred to me, therefore I am liable to compensate for that. I'm telling this example to highlight the fact that point of transfer of title or ownership of goods can be much later than the point of transfer of risk. I repeat, the point of transfer of title can be much later than the point of transfer of the risk, because similar things applies to in Incoterms, where when we analyze it, we will see that point of transfer of title or even physical possession can be totally different from the point of transfer of risk. Let us take another example where it is furniture which is not transported in your own car, but you go and buy and then you have to engage the service of another transport company or a small pickup to transport it to your home. But you are engaging there, so there is a contract of carriage where you are engaging a transporter to pick up the items from the seller's premises and transport it. And if they damage the goods, the seller is not liable because I am engaging the transport service. Look at another item like a television or a refrigerator, where you go, you select the item, you pay for it, and then the item gets delivered by the seller at their expense and risk maybe a week later. So in this case, I have already paid for it and therefore I have title on those particular goods, but the risk of damage or loss is transferring to me only when it is physically reaching my doorstep. So again, see the variation. Therefore, similar to the example I gave on the grocery shopping, please remember here that the title transfers first in the case of a television or a refrigerator, and the risk is transferring only later, much later, even in terms of time. Look at another example of, say, pizza being delivered at your doorstep. The seller is bearing the complete risk till such time it is delivered at the doorstep, including even the payment risk, where the payment, if it is not made in advance, it is being given only after delivery of the item. You are able to physically inspect those items, accept the items, and then pay for them. So you can see this complete contrast which is there, where in the initial case of the grocery shopping, you have the maximum seller with the buyer right from the time you pick it up from the shelf of the supermarket, to the other end of a pizza delivery, where there is minimum risk for the buyer, maximum risk for the seller, because till such time it is delivered and accepted by the buyer, the risk remains with the seller. So going back to this example of, say, crystalware, you would have probably seen this board that if you break it, consider it sold, which means that you may not get physical possession of the item, but the moment you pick it up, the risk is transferred to you, and therefore if it is broken in your hands because of your negligence, you are liable to compensate for the value of those goods. That was the end of part 1 of the series of 3 presentations on Incoterms 2020. In part 1, we had a complete introduction to the way the contracts are structured. And in the next part, we will see each and every Incoterm being explained properly. What are the pitfalls in that? What are the areas of ambiguity which needs to be taken care of? Thank you.